Judge Rodriguez with the Ninth Judicial Circuit Court is back to talk more about the guardianship process in Florida. Today we'll focus on one of the central requirements that must be met. That is the term capacity. Now we're probably familiar with it. Maybe we've heard it, on one of those legal TV shows about capacity and consent, which we're going to get to. But technically, legally, what is capacity?
Well, I will tell you first what capacity is not.
Okay.
Capacity or incapacity is not incompetence. Those are two words that have totally different meanings in the law. But we're not going to talk about incompetence. That's probably on the criminal side and the criminal side alone. Capacity is what someone has to have in order not to qualify for guardianship. And we always look, whenever we're looking at whether or not a petition for guardianship should be, entered and granted, whether or not this individual has some types of capacity, because guardianship removes a lot of civil rights, constitutional rights that are granted. So we're always looking for the least restrictive alternative. This is what we look for when we're looking for capacity. I just happen to have Chapter 744, which is on guardianship, particularly sections 12, A and B, that define it to a T. An incapacitated person means a person who has been judicially determined to lack the capacity to manage at least some of the property or to meet at least some of the essential health and safety requirements of that person. To manage property means to take those actions necessary to obtain, administer, and dispose of real property or personal property, intangible property, business property, benefits, and more. For example, if your Aunt Tilly is not paying her real estate taxes and it requires that members of the family come and reestablish and again invalidate the tax deed by paying the back taxes, something may be amiss with Aunt Tilly's capacity on the legal side. As to the personal side, if we are taking a look at Aunt Tilly and she's not combing her hair, she's basically not managing her
day-to-day activities,
or taking showers. If she's not doing things to keep herself just as gussified as she's always been and as you're used to seeing her, something's there amiss that may indicate that the capacity is failing and she might need that guardian angel. Right.
And now coming back to that word consent, how does that really differ from capacity to consent?
In order to be able to consent or to agree to something, you have to have capacity. So that's how they're interlaced. But consent means that you have full capacity, are able to understand what is happening, both legal as well as health-wise, and make decisions. Make decisions to agree or disagree to take a particular action. And capacity, again, depends on whether you've got it or whether you don't. And again, whether a guardian can come in, to help out.
Absolutely. So we certainly understand that, and we want to thank you for clearing it up. And we have it right from the iPad.
Right from the statute.
Right from the legal information. And again, thank you for explaining how capacity and consent is determined, and the importance of allowing elders to make their own decisions whenever possible. This interview is part of a series of interviews with Judge Rodriguez about guardianship.